Listen here. Okay. If you don't answer the question, I'm going to release the lawyers. 25-00791 FY, State of Michigan versus Timothy Dansby.
Yeah, people.
Morning. 7446, standing in for the attorney of record, Gonzalez, and appearing on behalf of Mr. Timothy Dansby, who stands to my right. Mr. Dansby, can you please state your full name for the record?
Timothy Dansby.
All right, Mr. Dansby, we're back. Do you mind having Ms. Miller stand in for Mr. Gonick for today's hearing?
That's up to the court. I still reserve my right. I mentioned all of the previous hearings, but part of today's process has been going what it's going to continue doing what it's doing. But I still
Does that mean you don't mind her standing in?
want to interpret.
Okay, you know what? I'm not going to play that game. That's a yes or no question.
All right, everyone, buckle up. This case is already off the rails in the very first minutes. We're in Michigan, and Mr. Timothy Dansby is front and center, but right from the start, you can feel the tension. The judge is trying to get a simple answer. Does he want a lawyer or not? And what should be a routine procedural step quickly becomes a battle of wills. Mr. Dansby's back and forth, refusing to answer yes or no, sets the stage for a courtroom showdown you don't want to miss. Stick around, because the way this case unfolds highlights the chaos that can erupt when courtroom procedure meets outright defiance.
Okay, do you want to adjourn it and see who it is? You have a right to have the counsel of record present if you want to be here instead of Ms. Miller. And this is basically for a probable cause conference and adjourn date on a retail fraud first degree. When we had adjourned it before for your lawyers to get video discovery. So do you mind her standing in or no? Okay, so you don't want a lawyer, sir? I'll release him if you don't want one. Nobody's going to force you to have a lawyer to help you. If you want to do it all yourself, do it. Do you want me to release the lawyers?
You know, thank for him soon right now.
Do you want a lawyer? Yes or no?
Here's where it gets really interesting. The judge is attempting to clarify the defendant's intent. Does he want legal representation or not? Mr. Dansby's refusal to give a straight answer isn't just stubbornness, it's a tactical move. By prolonging this simple question, he's effectively putting the court in a procedural loop. Notice how the judge carefully explains that no one will force a lawyer on him, but still must ensure he understands his rights. This is a classic clash between courtroom authority and individual autonomy, and it's fascinating to watch because it immediately raises the stakes. Will he cooperate or force the court to reset entirely?
It's a real easy question, sir. It don't take all day. Listen here. Okay, if you don't answer the question, I'm going to release the lawyers. If that's what, because you've been complaining the whole time about, I didn't ask for no state attorney. I don't want to, I don't know what it, whatever you going to do. No, I'm not doing anything. I didn't appoint the person in the first place. I didn't do it. Okay, so you don't want them? Is that what you're telling me? Do you want them? Yes or no?
All on the same.
Sir, listen, this is not going to be a matter of semantics. Do you want one or not? Because nobody's going to force a lawyer on you. I'll be happy to handle this case with you by yourself, doing whatever you can do to help yourself. If that's what you want.
I still ain't got my discovery, so.
So, do you want a lawyer?
I'm sorry, I'm standing on the same thing I stand.
I don't even know what that is. Whatever your claim is, I don't know. Okay, let's release the lawyers. All right.
Now watch this moment, things start to escalate. The back and forth is repetitive, almost circular, but it's revealing. You can see the frustration from both sides. The judge trying to maintain order, Mr. Dansby standing firm on his terms, and the audience left wondering, what is his ultimate goal? This is a prime example of courtroom drama where the tension isn't in testimony or evidence, but in pure human interaction. It's like a chess match, every word, every pause, every refusal to answer adds pressure, and suddenly a procedural hearing feels like a high-stakes thriller.
Now, you're not getting another one. I'm just telling you.
I reserve the right for judiciary finding on the legitimacy of the court.
You're not getting another lawyer, okay?
Oh, yeah, I said
I don't know what you can reserve what you want. I don't mind.
finding of the court and the legitimacy of the court as far as the argument practice.
Sir, whatever you want to do, you can do. But since you don't want a lawyer, I can't by law give you one. So
That was three adjournments ago.
guess what? So
Lord, have you given me the things that I need?
okay, sir, nobody can give you anything but a piece of paper. They can give you that. They could give you the police report. They cannot give you the videos because there's no way for you to watch them.
Make sure that the law library at the court give order that the law library at the court need to have a clerk or somebody to present the information for me to see the video. I don't know. Maybe you just don't want to get done.
Sir, I don't even know.
I know.
I don't know anything about your law library wherever. All I know is these video files. They're files. They come on a computer.
That's right. So the law library should somebody should be giving people at the law library that heads up to make it.
Well, you know what? That's up to you to figure out how you're going to get them.
Here, the conversation shifts to discovery. Mr. Dansby expresses concerns about not having received the evidence he needs, videos, documents, all the material that could affect his defense. The judge explains the limitations and responsibilities clearly, but notice the subtle friction. The defendant wants access, but perhaps not in the conventional way. This moment is key because it highlights a fundamental tension in the justice system. How do courts balance a defendant's right to be fully informed with procedural rules and practical constraints? For viewers, it's a peek into the behind-the-scenes workings of legal strategy and courtroom procedure.
I'll let the second circuit figure it out. Let the second circuit figure it. You know, probably judge, second court, Supreme Court, we let them figure it out. I'm straight. Well, I ain't doing nothing.
Ready for me to take them?
Your Honor, would you like, Mr. Donovan to file any sort of motion or
No,
order to have him withdraw?
no, I'm going to write an order out right now, releasing him.
Yeah.
And so we will reset this, I guess. I don't know why we got him. We could actually bring him back out. And he could decide what he wants to do today.
I do know that, he is wanting to have his preliminary examination. That is.
Okay, well, let's set it for an exam then. How many witnesses, Mrs. Shockley?
Probably just me one.
All right. You want to wait for your order, you can.
Okay, thank you.
Right here, you see the court trying to reset the proceedings, schedule a preliminary exam, and factor in the time it will take with a single witness and one defendant. But Mr. Dansby's demeanor underscores one of the most challenging dynamics judges face, managing a defendant who both knows his rights and chooses to push boundaries. The judge remains calm, professional, and firm, but there's an underlying tension in every word. For the audience, this is where the drama peaks. The clash of authority and personal agency makes for an unexpectedly suspenseful procedural hearing.
One witness.
Yeah. One witness and one defendant that's going to make it way longer than it's supposed to be. So factor that in.
What's available October 3rd at 10:30?
All right. So October 3rd at 10:30. Is the exam date. And could you ask Mr. Gonick to make sure he gets a discovery, what he has, over to this person?
I believe that paper discovery has already been given to him. I'll see if the court or if the jail will allow us to give any sort of thumb drive or anything like that that encloses the videos.
This record, I would advise the court the discovery, the AV discovery in this matter is 99% police body worn camera, which has the defendant in it, and there's only one in-store video of the defendant walking past that. So, you
Okay.
should know it.
Okay. Well, good. Just make sure he sees it.
That's
Just some of your best efforts on that. And here's the order.
Now pay attention to how discovery is being handled. The judge emphasizes that body cam footage is almost entirely what the defendant will see, along with one in-store video. This may sound straightforward, but the logistical and legal challenges are significant. How to ensure the defendant has meaningful access to evidence while respecting legal rules and jail protocols. For anyone interested in legal mechanics, this is a goldmine, because it shows that even a seemingly simple procedural step requires careful planning and communication. And yes, it adds yet another layer of drama to an already tense hearing.